I'd like to first thank all of you who helped support our work in Annapolis this past session. Hundreds of folks took action alerts on bills like the Child Interrogation Protection Act and our marijuana legalization efforts. And many of you made numerous calls and tuned into hearings and town halls to get informed. So thank you for that. And also big thanks to all of our local partners, especially those in the Maryland Coalition for Justice and Police Accountability, for all of their commitment to focus and to work on implementing the police accountability boards locally in their local counties. For months, dozens of organizations and groups have rallied and organized locally from Calvert, Prince George's County, Montgomery County, all the way to Wacomico, Anne Arundel, and Baltimore County. Folks have showed up and have been consistent in the demand for a strong police accountability board with strong community oversight powers. And this work would be impossible without the work. This work would be impossible without all of the support and work of our local partners. So thank you again, and thank you again for being here. And I'll turn it over to Meredith to get us started for tonight.
Thank you so much, Yannette. Yannette, our newly appointed public policy director, who did an amazing job leading our work in the 2022 legislative session. So tonight we are going to be hearing from some really important speakers who are key to our work. Yannette Emanuel, who is our director of public policy. Frank Patinella, who's senior education advocate with the ACLU of Maryland. Charlamar Douglas, who's the chair of the Maryland Alliance for Race Equity in Education. Davon Love, director of public policy from Leaders of a Beautiful Struggle. Lawrence Grand Prix, director of research for the Leaders of Beautiful Struggle. And Joanna Silver from the Silver Spring Justice Coalition. And the first topic that we're going to hear about tonight is marijuana legalization, and specifically the work that we've done with partners to make sure that race equity is focused in that effort. First, we are going to hear from Yannette about marijuana legalization. Go ahead, Yannette.
Thank you. So this past legislative session, marijuana legalization was finally taken up in Annapolis. And we at the ACLU have been tracking complaints that have been coming in to our intake line related to marijuana and tracking arrest trends, both pre and post decriminalization, to really ensure that the criminal legal reforms that we advocated for really got to the root of the problem. And we've been working closely with our partners at Leaders of Beautiful Struggle, who have been studying what other states have done, and especially how to just get the reinvestment piece here right in Maryland. And so I'm excited we'll be joined by Lawrence, who's going to talk a little bit about his research there and where we ended up. And our goal this session was really to make sure that we centered racial justice and equity in our efforts to legalize in Maryland. So this past session, we supported SB 692 that was introduced by Senator Jill B. Carter. And this bill really sought to, one, legalize recreational use of marijuana, prohibit the odor of marijuana alone from being used as probable cause to search a person or their vehicle. Additionally, vacate previous marijuana-related convictions and mandate opportunities for reconsideration hearings for those who have been convicted of other low-level felonies and misdemeanors if those charges stem from a conviction based on a search due to the odor of marijuana. And additionally, SB 692 sought to establish reparations for communities directly impacted by the war on drugs. And the goal here was to create reforms that, again, actually offered redress to those harmed by the racist war on drugs due to the racist over-policing of Black and Brown communities, and really change the way that we police marijuana post-legalization in order to make sure that we're actually reducing the racial disparities in arrests. But unfortunately, SB 692 was never brought up for a vote in the Senate Finance Committee. However, legalization did still move forward. And so the General Assembly passed two marijuana bills this session. One was HB 1, which put the question on the ballot this November. And the other bill, HB 837, to start to address the racially biased enforcement of our marijuana laws. And so HB 837 is contingent on the passage of the ballot measure, which and HB 837 will allow, if we can move to the next slide. Next slide. Next slide. There we go. Will allow the expungement of possession with intent to distribute after 3 years and the completion of any mandatory supervision or including probation and parole. HB 837 will also allow the automatic expungement of single possession of marijuana after a year. And it will also allow individuals to grow up to 2 plants per household, and it will increase the allowed personal amount from 10 grams to 1.5 ounces. And we have a flow chart that we can drop in the chat that breaks down when these different provisions will go into effect, and everyone should check that out. Additionally, the bill fails to do what we were advocating for as far as the criminal justice reform piece goes, and really changing the way that we criminalize marijuana moving forward. And so the bill still does allow for police to conduct warrantless searches of a person's car solely based on the odor of marijuana. And additionally, it still criminalizes possession over the legal use amount, and that it carries, that is a misdemeanor offense. It carries up to potentially 6 months in jail and is $1,000 fine. And furthermore, we're still criminalizing possession with intent to distribute, and is now a misdemeanor instead of felony, but still carries up to 3 years in jail and a $5,000 fine. And one of our main arguments during session is that if we're going to be legalizing marijuana, we should be changing the way we treat it, recognizing that we were wrong for the way that we criminalized it, and understanding the racist policing practices that went into driving our the racial disparities in arrests, that moving forward, we shouldn't be continuing to criminalize these quote unquote offenses, and instead treat them as civil offenses rather than criminal. But unfortunately, that did not move forward this session, and that is something that we're going to continue to advocate for moving forward. But nonetheless, there was some successes this session, and I'll turn it over to Lawrence to talk a little bit more about that.
Thank you, Yannette. Lawrence Grand Prix, Director of Research for Leaders of a Beautiful Struggle. So this is an issue that I personally have been working on researching 7-8 years in light of the legalization campaigns in Colorado and Oregon. Kind of realized that they were attaching these large taxes to recreational cannabis. The obvious corollary was that's a lot of money. We need to fight for that money. And what are they doing with the money? Because given the harm of the war on drugs, it's necessary to reinvest that in communities impacted by the war on drugs. So part of what I've been doing is researching other states. Every state's different. There are a variety of bills. Needless to say, I don't think any of them have done the best job. California dedicates 10% of all revenue to police forces. So police forces have actually seen some of them have seen an increase in their funding strictly from cannabis legalization. Those funds go directly to them. And seeing other states, Colorado, I think actually gave people in the state a tax rebate from the cannabis legalization funds, and every state does everything a little bit differently. And to me, it was just kind of an example of a policy failure where advocates need to really vigorously advocate for these funds to not just generally go to good stuff like funding programming, but really funding in a manner that reflects a vision of what one could call reparations. And the difference between funding and reparations is funding is just money you give to good stuff, basketball camps, community cleanups, like that's fine. But reparations is a recognition of a harm that comes with resources for the entity that is aggrieved by the harm to choose for themselves the mechanism of redress. And that's what was missing in other states more than anything else, is what is the actual mechanism of community control for the communities most impacted by the war on drugs to choose for themselves what programming, what mechanisms they would actually want to see be invested in their community, because the war on drugs doesn't just lock up individuals. Some communities in Baltimore had up to 20% of the entire population of the entire neighborhood in jail. And that just hollows out the entire community. It hollows out community institutions. It hollows out civil society. So you can't just, even though it's important, give people resentencing, give people expungement, and give individual people some redress. You have to give communities redress. And that's what the community reinvestment and repair portion of HB 837 is all about. So as of right now, of all the tax revenue that's going to be generated by recreational cannabis, the number we have right now is 30%, no less than 30%, will be allocated to this community repair fund, with the idea that as opposed to having the fund centralized in, as some of you may know, a very obtuse, sometimes very really anti-democratic top-down system of Annapolis, the funds will go, first of all, to localities based upon their actual impact from the war on cannabis. So the comptroller will actually be asked to do a statistical analysis of cannabis arrests during periods of the highest enforcement of cannabis prohibition to graduate and to weight the funds in terms of how they are dispersed to the communities that most imprison people for the war on drugs. With the idea that, given constitutional limitations, we can't just say give money to Black and brown people, but because of the racialized war on drugs, that statistical measure could probably track where the most damage has been done and repair that damage, which has largely been Black and brown communities. So that's the first proportion I think is very novel, unique, and not seen in other states, which can get us a better result. The second provision is that with certain guidelines and certain provisions, the funds will not be centralized in Annapolis, will be given to localities themselves. This will give people at a local level who oftentimes don't have access to their state senator or delegates, but do have access to City Hall and do have access to a more robust local democratic processes that they can touch more and they have more control over. The locality itself will have to issue a provision, not through the executive. So not through, just the mayor or the county executive doing whatever they want with it, but through the city council or county council. And that will give the community an actual clear point of leverage to be able to influence for themselves who holds the money, what democratic processes do they use, what types of things is the funding going towards. Because as someone from Baltimore, I don't know what PG County needs to repair the harm for its war on drugs. I don't know what Charles County or the Eastern Shore or Western Maryland might need. This fund actually allows the funding to be more modular and to be applied to local context, which is something critically lacking in most dominant funding practices that have this idea of a universal best practice that is being attempted to be ported all across the state and all across the country, and really oftentimes not responding to local conditions. So again, with the theory that reparations is the people who are aggrieved by the harm choosing for themselves a mechanism of redress, we have the ability to actually have a reparations-based theory of funding here in Maryland. But it all depends on what happens in 2023. So obviously, the referendum has to pass, and then after it passes next session, we're going to come back and we're going to have a chance to update most, if not any of this stuff. 30% is really just the floor. As you know, I believe we'll talk about, we're hoping to increase that to match what other states are doing. One thing New Jersey is actually doing pretty well is I believe they have 60% of funding of their statewide cannabis funding in a similar program. I don't know if it has all the local empowerment provisions that we have, but yeah, 30% obviously is the floor, and we're going to push for far more. We can't obviously do anything to the scale of the harm of the war on drugs, but this will at least give people a real opportunity to turn what can be a substantial amount of funding. I don't want to throw out any numbers, but it's going to be in the 9 figures in terms of how much tax revenue this is, and we need to make sure it goes to our community.
Absolutely, perfectly put. So as Lawrence mentioned, there's still a lot more work to do, and especially making sure that we're getting more percentage of the tax revenue going into this fund, but also on the criminal justice reform portion as well. If we're going to be legalizing, which, it's very likely that the ballot measure will pass. We know that around 70% of Marylanders, and there's strong support across party lines for legalization. So the ballot measure, it's very likely will pass, but there's still work to do after that. I think the legislators, for the most part, understand that, and we're going to have to continue to remind them of that as well, especially around prohibiting the odor of marijuana from being used as an excuse to search people, because otherwise we're going to continue to see these racial disparities in arrests. We've already seen that in other states that have legalized, even post decrim and even legalization. It wasn't enough to actually reduce the racial disparities in arrests, and that's because we need policies that address the racist police practices and also just how we're treating marijuana moving forward. If it's good enough to legalize and the state collect tax revenue from it, then we shouldn't be continuing to criminalize other folks who are are probably doing the same thing, trying to get by. And instead of criminalizing, creating incentives to allow them to be able to participate in the market in different levels of it, but definitely not criminalizing it, understanding all the things that we've learned or we've said that we've learned up until this point, as far as, criminalizing folks is not actually doing anything for public safety, and that actually, having folks get entangled in the criminal legal system, it does far more harm than it does good. And looking at the trends, court trends that came out last year, we saw that at least 50% of the individuals who had their first entanglement in the criminal legal system was due to a marijuana related arrest. So it's actually causing more harm, and criminalizing it does nothing good for public safety. And it's time to move away from that and learn from our best practices and be intentional in that and how we legislate around marijuana legalization. So there's still definitely lots more work to do, and we'll still continue to need your support, both back in Annapolis, but also locally when we're advocating for how this fund is going to be used locally as well. And turn it back over.
Thank you so much, Yannette. That is such inspiring work. Yannette and Lawrence, really important work that's going to be growing in the future as well. Next, we're going to hear from Yannette, and who's going to be talking about the efforts to make changes to the Baltimore Civilian Review Board in light of the legislation that passed last year that requires police accountability boards in every county and Baltimore City. Go ahead, Yannette.
Thanks, Rita. So as I mentioned at the top of the town hall, last session, we passed police reform legislation that required that each jurisdiction in the state of Maryland create a police accountability board. Well, the Maryland General Assembly first established the Baltimore Civilian Review Board in 1999 with the authority to receive and investigate certain police misconduct complaints. And so as we mentioned last session, the General Assembly passed the Maryland Police Act of 2021 that required these PABs. But in that process, Baltimore City and even Prince George's County already having oversight entities was overlooked. And so the state legislation that passed requires that these PABs are tasked with reviewing complaints from the public and appointing administrative charging members to the administrative charging committee, which is an internal police department trial board, among other responsibilities. But a lot of these PAB responsibilities conflict with what the CRB is already doing. And so due to the conflicting statutes and similar functions of both entities, this last session, the ACLU and the Maryland Coalition for Justice and Police Accountability, as well as other local Baltimore groups, supported HB 991 and SB 441, which was introduced by Senator Jill P. Carter and Delegate Stephanie Smith. And what this bill would have done is would have allowed the current Baltimore Civilian Review Board to absorb the responsibilities and duties that are assigned to the PABs. Additionally, it allowed the CRB to attain independent counsel and receive adequate funding to carry out its duties. And these demands are consistent with what other jurisdictions, what we advocated for last session in Annapolis, but also what other local jurisdictions have been advocating for to strengthen their police accountability boards as well. The bill passed in good posture out of the House, but unfortunately, due to the Baltimore Mayor's Office backtracking on an agreement and unwillingness to create a stronger CRB and instead shift power to the Administrative Charging Committee, which would still be living within the internal police disciplinary structure, that bill did not pass out of the Senate. Moving forward, now the city will have duplicative oversight boards that overlap, and by design are not going to be as effective as one strong oversight entity with these independent powers would have been. But currently, there are efforts in City Hall in Baltimore City to establish a police accountability board. So the CRB is still intact. That legislation did not move. And so the CRB will continue to exist. But at the same time, the Baltimore City Council is moving forward with creating a police accountability board. And we're just trying to make sure that the membership adequately reflects the community, and that they have the proper funding, and that they're able to they're able to share their findings with the community as soon as they're able to. And there's some transparency and a way for the two entities to be able to at least work cohesively together as possible for now. And so I'll turn over to Lawrence to give us some more background context just about the importance of community oversight, but also making sure that the membership actually reflects the community.
So the theory is that until you actually have some external entity that has power to actually investigate and or punish police officers, there's not really going to be a substantial deterrent for negative police behavior. Police, as my father was a cop for 20 years, they say things like, it's better to be, judged by 9 than carried by 6, in terms of it's better to go to jail for using excessive force than to die on the streets. There's an obsession with safety and, coming home. And so that's just this huge incentive to jump the force continuum in moments of acute fear or panic. And unless you can really say, like, you won't be able to feed your family because you will be fired, it's hard to break into that structure of deterrence. So it's not just about doing the right thing, just the right thing to do. It's about having a legit deterrent to police behavior. And secondly, it's about creating a proof of concept that shows that these people truly need to be public servants, so they have to serve us, the community that pays their salaries through our taxes, and that they're ostensibly supposed to protect. And this has become a very technical, very technocratic situation. But if there's one thing briefly that folks need to take away, is this is about control. The PABs and the CCCs, it's all about the more control you have from the city's perspective is the better. Because, they want to be able to control the process of who gets on the trial boards, of who does the investigations. And the problem is that the more you bring into the orbit of the city, the less actual independence the entity has. So if you want to actually have people trusting this entity to deliver their complaints, they need to trust that the entity can operate in good faith. So it has to be independent. It has to be community accountable in terms of who actually staffs it. And they need to have enough funding to, as Yannette said, be able to hire independent counsel, to potentially have subpoena power, to actually be able to have people actually come before them and tell their story, and need to actually have teeth and actually obviously the changes we're trying to bring in. So the fundamental concept is, and last thing I'll say is that the police department in the bill that passed, again, it wasn't all bad. We just need to improve it substantially and not have it be co-opted. Part of what's confusing is that the mayor and the police department use this language of civilians. So having civilians on the charging committee and the PAB equals community control. All civilians means that they're not police officers. But who appoints these people? What networks do they come out of? Are they administrative law judges? These are really technocratic lawyers who no one in the community can get them hired or fired to have any power over them. So just because it's a civilian does not equal community control. They'll use civilian control as a proxy for community control. But if they control the civilians, then it's not community control. It's the city picking which civilians it wants to interface with the police department. That is not community control. That wasn't the spirit that led so many people to protest and to come to Annapolis over the past 8 years working on this issue. And we need to ensure that this is not, in the midst of all this technocratic complexity, the heart of the issue is not lost. Community control is the only deterrent to negative police behavior, and the community has a right to control and have meaningful investigatory and disciplinary power over police, period.
Perfectly said again. And just reiterating what Lawrence said, the likelihood of getting caught is a deterrent, not increasing the sentencing, not having more severe punishment. And that's consistent with, street crimes as well, or crimes outside of just policing, but also applies to policing as well. And so it's critical that we do have this external independent agency, an entity that is made up of the community, that is able to actually make sure that police are being held accountable for misconduct. Otherwise, we're just going to continue to see a cycle of police continuing to police themselves. So there's definitely more work to do there, and something that we're working on across the state with the implementation of these boards.
Thank you so much, Yannette and Lawrence. Next, we're going to hear about a really important bill that finally passed this legislative session that protects the rights of children who are being interrogated by police, an issue that we have worked on for many years. Yannette, please talk about this really important bill that passed.
Yes. So, as many of you already know, every day children become entangled in the criminal legal system when they are questioned without a parent or attorney present. Children are more likely to admit guilt even when they are innocent. Studies show this. Studies show that children waive their Miranda rights at a rate of 90% and make false confessions at a higher rate than adults. And so, as a result, they face criminal charges, prosecution, and incarceration without basic due process rights that adults are entitled to. And so we have examples of this that we've seen nationally. We've seen this, what happened in New York with the exonerated 5, but also here in Maryland with the Harlem Park 3, Black children who are, were coerced into confessions and had decades of their lives stolen. And so this was a really important bill that was spearheaded in the legislature by Senator Jill P. Carter and Delegate Sandy Bartlett, who introduced this bill for the last 3 sessions, and this bill was supported by the ACLU, but also our partners at LBS and the Maryland Youth Justice Coalition, which really prioritized this bill because understanding this is a very common sense bill, but also a really important bill. And so what this bill does is it puts proper mechanisms in place to protect children's rights by requiring that an attorney first be consulted with when a child is first interrogated by law enforcement, and it also ensures that parents and guardians for the child are properly notified when the child is taken into custody. And then finally, the bill allows for the Maryland courts to create age-appropriate language when reading children their rights. And so again, I said this is the 3rd session this was introduced. It passed with a veto-proof majority. The governor did veto it, but thanks to us having the veto-proof majority, we're able to quickly overturn that bill during this session, and that will be enacted October 1st of this year.
Very exciting, and thanks so much to all of those who have been taking action on that bill for the last several years. Next, we will hear from Yannette, who's going to talk about our efforts to protect the rights of people who are seeking medical parole in Maryland.
Thanks, Meredith. And this will be my last time. And so last year, as all of you might remember, the General Assembly successfully removed the governor from the parole process. This was a bill that we've been working on for over a decade. Before last session and before SB 202 passing, Maryland was one of only 3 states that allowed the governor to overturn parole decisions for individuals serving sentences for life with the possibility of parole. So luckily that, finally that bill passed, but however, due to a drafting error, the bill that did pass and has since been enacted excludes medical parole because that was located in a different section of the code. And so making so that medical parole is the only type of parole that would require a gubernatorial action. And so this session, we worked to remedy this error by supporting a technical fix bill, HB 920 and SB 774, introduced by Delegate Sandy Bartlett and Senator Jill P. Carter. And unfortunately, although the bill was adopted, passed out of the House Judiciary Committee in good posture, a harmful amendment was adopted on the floor, and the cross-file for the bill, SB 774, was not brought up for a vote, and so ultimately that bill did not move forward this past session. And what that means is that unfortunately the governor was not removed from the medical parole process this session, which is a serious problem because because the need for the Parole Commission to be able to act expeditiously is arguably the most critical in those cases where the parole candidate is seriously ill or dying. So this is something that we'll resume to work on to ensure that we fix this problem, and will be a priority for us next session as well.
Thank you so much, Yannette. Next, we are going to hear from one of our key partners, Joanna Silver, who is co-chair of the policy committee for the Silver Spring Justice Coalition, who led the effort to pass Quamina's law, which would expand body-worn camera use by police. Joanna, please go ahead.
Thanks so much, Meredith. Thank you for including me and the Silver Spring Justice Coalition in this program. SSJC has learned so much from our work with the ACLU and with the Maryland Coalition for Justice and Police Accountability. And we were really glad to have been able to work together on Quamina's law this year. So SSJC took the lead on this bill because it came from a member of our community in Montgomery County. Melody Cooper, the mother of Quamina Okran, approached us after Quamina was killed by Gaithersburg City Police. And she came to us to find out what she could do in response to her son's murder. She wanted to do something to help other families avoid going through what she had experienced. Quamina was killed on January 8th in 2021 by a unit of plainclothes police officers from the Gaithersburg City Police Department. And Gaithersburg City is one of the 88 municipalities or separately incorporated cities or towns in Maryland with their own police departments. And because these officers were not in uniform, they were not wearing body-worn cameras. And while a prosecutor did convene a grand jury to investigate the killing, all the grand jury really had was the word of the officers themselves and very limited forensic evidence. So without the benefit of any body-worn camera recording, the grand jury did not charge the officers with any crimes. Now, shortly after Quamina was killed last year, the Maryland General Assembly passed the statewide body-worn camera requirement for the very first time, and that was SB 71. However, we learned after the fact that that bill did not expressly apply to plainclothes officers. And we also learned that it only applied to county police departments, so it didn't apply to any of the state's 88 municipalities that have their own police departments. So we worked with Delegate Leslie Lopez, whose jurisdiction includes the city of Gaithersburg, and with Ms. Cooper and with our partners around the state to draft Quamina's law to address these loopholes in last year's law. And unfortunately, the bill did not get a vote in committee. So our goal was to expand the body-worn camera requirement to apply to plainclothes police officers and municipalities. And unfortunately, we didn't succeed this year. And we're still processing all of this and learning from what did and did not happen. But I wanted to just spend a few minutes sharing some of the reasons we think the bill did not move and some of the other lessons we learned that we're going to take from to move forward next year. So first is that there were two other body-worn camera bills introduced this year. One would have just expanded last year's law to municipalities, and that was Delegate Moon's bill. And the other was very different, and it would have vested financial and regulatory authority for body-worn cameras with a state agency, and that was Delegate Lewis's bill. And both of these bills got Senate cross files, but unfortunately the senator who filed them did not want to add our bill to the mix. It went beyond what he was interested in doing around body-worn camera legislation this year. So one thing we're going to be doing next year is trying to look at how we can work together with Delegates Moon and Lewis to try to package our bills and ensure that we can get a supportive Senate cross-file. You know, that said, none of these body-worn camera bills actually moved out of committee in either the House or the Senate. And we think this is likely because there appeared to be little appetite for policing reform legislation this year after last year's really significant focus on these reforms. However, in the end, there were some fixes. A number of us were following to last year's policing reform bills. So we're hoping that that door stays open and that next year there still will be energy to address some of the other needed fixes like these loopholes in our body-worn camera law. Another thing I wanted to share is that, you know, despite the fact that this bill didn't get to a vote, our hearing in the Judiciary Committee in the House actually went really well. There was no substantive opposition to what we were asking for from the other side. No one really seemed to object to the idea of having cameras on plainclothes officers or municipal police officers. The one glaring exception is that expanding body-worn camera use to municipalities was opposed as an unfunded mandate. And I think it's worth pointing out that one of the reasons why there was not a lot of opposition to the substantive idea of this expansion is because we learned through our research that there actually are already a number of counties and municipalities that already require cameras for plainclothes police officers, including the city of Gaithersburg. So interestingly, shortly after Quamina was killed, Gaithersburg City amended their body-worn camera policy to include plainclothes officers. Now, the unfunded mandate for municipalities is a bigger challenge, and we're going to have to work with Delegate Moon and the other supporters of this bill, of the other supporters of this municipalities part of this bill, to address this issue next year. We think there are a number of ways to deal with this, including through a funding measure, though candidly, the Silver Spring Justice Coalition's organizational position is that we should not be adding to policing budgets, and that money should be moved from areas of policing where it is doing more harm than good if we do have a funding need. And then last, but definitely not least, that we learned a lot about this year and really spent a lot of time working on and will continue to work on, is that some legislators and members of our own community have real concerns about the relationship between body-worn cameras and community surveillance. And we take these concerns really seriously and want to figure out how we can better address them next year, possibly through additional legislative safeguards, adding some language to address this in the bill, but also through dialogue around the fact that plainclothes officers already engage in a significant level of community surveillance. That's really the nature of their work, to blend in so they can observe what is happening without being noticed. And Quamona's law would simply say that once an officer moves from watching to acting, so once an officer actually starts to engage with a member of our community by exercising their authority as a police officer, they should be required to record that interaction. The other thing is important to remember is the significant harms that plainclothes officers in particular cause in our community. They have far higher rates of excessive force and misconduct than uniformed officers. They were at the heart of the Baltimore Gun Trace Task Force scandal, and cities like Baltimore and New York City actually scaled back the use of plainclothes officer units in response to their excessive use of force and misconduct. Now, unfortunately, we've been hearing that the use of plainclothes officers is increasing again in response to perceived increases in violent crime. So it really is essential that we find out how we can protect the public by making sure that these officers in particular have cameras on them. So thank you again for including us in this important work, and we look forward to working with all of you to try to pass this bill next year.
Thank you so much, Joanna. We look forward to working closely with the Silver Spring Justice Coalition going forward. Next, we're going to talk about the last subject area that the ACLU of Maryland prioritized for this legislative session, related to the state constitutional right to education. We're going to hear from Frank Patinella, who's a senior education advocate with the ACLU of Maryland. And we're also going to hear from Charlemore Douglas, who's the chair of the Maryland Alliance for Race Equity in Education. Frank, please go ahead.
Great, thank you. Before we dive into what happened during, can you go back to the other slide? Thank you. Before we dive into what happened during the legislative session in education, I want to give a little context on education funding to help listeners understand the numbers a little better. Not many people know that Maryland's Constitution guarantees adequate funding for all public school students in the state. So what does that mean? The first time it was defined came in the year 2000, after the ACLU sued the state on behalf of Baltimore City families who contended that their schools were grossly underfunded, and that the state was in violation of its constitutional obligation. We won that lawsuit, and the judge ordered that the state bring its funding formula for education in line with its constitution. The state put together what was known at the time as the Thornton Commission, which developed the new education funding formula for all schools in the state. The Thornton Law was adopted in 2002, and it set what was called adequacy funding targets for each district. So this was the amount of funding that the state itself determined was needed for each of these districts to meet its constitutional funding level. In 2002, the state legislature passed the Thornton Law, and $1.3 billion in new funding was phased in and distributed to schools statewide. Districts met their target funding levels in the year 2008. So great, right? Well, no, that was the year that our nation fell into a recession. The state cut the education funding formula, which prevented planned increases in funding over the next decade. So how well are districts funded now? Let's take a look at the next slide. So this is a snapshot in time for fiscal year 17. Due to the cut to the Thornton law in 2008, the gap was 1.5 billion statewide. That's $342 million for Baltimore City, 500 million for Prince George's County. And you can see other districts in terms of how far they're falling short from that middle line. That middle line represents the adequacy funding level that each district needs to meet, right? Based on what the state itself defined as adequate funding. And if you look at the districts on the far left, starting with Caroline, that's the district of the lowest wealth. And as you move to the right, districts get wealthier, right? And Worcester County is the wealthiest. So you can see the districts of the lowest wealth towards the left are the most underfunded, right? Represented by those red bars. Other districts are at different levels in terms of their shortfall. And then there are a handful of counties that are above that line that are better funded than what the state itself determined to be adequate. Excuse me. So now we're in year 22, coming up on 22-23, and we know that every year that this gap grows. So when I report on the numbers for this fiscal year, just keep this picture in mind, okay? Next slide. In 2020, the state legislature passed the Blueprint for Maryland's Future, or the Kirwan Bill, based on the work of the Kirwan Commission, which started in 2015. This is the education reform initiative that the state adopted that will be in play and that will affect the next generation of students and families. It will infuse almost $4 billion more into our public schools over the next decade, and both the state and local governments are required to contribute funding to this plan. It calls for universal pre-kindergarten, a new college and career readiness program. It provides a lot more funding for students from low-income families, those that require special education, immigrants and English language learners. There's more funding for schools with high concentrations of poverty, for wraparound services, site-based healthcare, and mental health resources. So in terms of the resources, there's a lot to be excited about. And this is the first year of phase-in. Overall, funding is trending in the right direction. Those gaps in funding that we saw are starting to get filled. This coming school year, fiscal year 23, there's 456 million more for schools statewide coming from the previous year. But we had to fight for that full amount because the governor omitted $140 million in his budget. And I want to introduce Charlamar Douglas, chair of the Maryland Alliance for Race, Equity, and Education, to talk about what we did to ensure that 140 million was added back to the budget. Charlamar, are you with us? Oh, there you are. Oh, no. Okay, it looks like Charlamar's mic is not working. It's too bad because she really did a great job in leading us this year through the Maryland Alliance for Race, Equity, and Education to get that money restored. And the way the budget works in our state is that the governor is the only one that has the power to add money to the budget, especially when it comes to education. So when we saw that $140 million missing in the budget, I spoke with Charlamar and the coalition, and we decided that we wanted to step out and make a lot of noise about this. And the only leverage we had was to, publicly shame the governor for not including that $140 million. That $140 million, most of that funding is through a measure called the Education Effort Adjustment. So this is a particular mechanism in the bill that triggers more state money for districts of low wealth that have high local contribution requirements. So Baltimore City and Prince George's County, $99 million and $25 million respectively, was owed by the state to those districts. The governor believed that it was optional to include in the budget this year. We pushed back and said, no, this is not optional. We fought for this measure in the bill because without it, we knew that the bill would be wholly and completely inequitable in terms of how the funding formula treats districts of low wealth with high local contribution requirements. So we held a press event with Shalimar leading us, and we called on the governor to issue a supplemental budget in the amount of $140 million to make the budget full for this year. It didn't take long. Other players, including Strong Schools Maryland, legislators, other coalitions jumped in, the state's teachers union, everyone calling on the governor to release a supplemental budget. Unfortunately, we got a response within a week. Shalimar, are you still working on your mic? I'm sorry. Okay. So
Can you hear me?
yes, there you are.
I think
Okay.
you can. Okay.
Yes.
I thought to log in through my phone.
That worked.
I'm sorry. My microphone on my computer is not working. So thank you all for your patience. So I think Frank has said the bulk of what Mari did along with other coalitions when it was brought to our attention that the governor had cut these dollars, and the dollars that were cut in the state budget were specifically from Baltimore City and PG County, where we have the most number of Black and Brown students throughout the state in those two LEAs. And so what our policy team decided to do was to write a piece in the press about it, and to also call a virtual press conference, bringing to people's attention that this act by the governor is continued systemic and structural racism, to call it a racist act and not to be shy about that it was intentional. It was not accidental that Baltimore City and PG County were directly impacted by the cuts. And we also called out that the governor has not supported this the blueprint for Maryland in general. And we have spoken out about the makeup of, at one point, the makeup of the AIB board. Then he wasn't doing what was necessary to get them in so that they could get started. And so everything is delayed a year now. And thankfully, Mari, along with many other coalitions and organizations such as the ACLU, amplified their voices. And within a week, the governor had reinstated this money and other dollars that had been taken out of the state budget or not included from the beginning.
Thank you, Shalimar. One more, can you go back to the previous slide? Just real quickly. Okay, another bill that passed this year, House Bill 1469, is called the Maggie Mcintosh Art Fund. She was a longtime Baltimore City legislator and chair of the Appropriations Committee over the past several years. This bill includes $250,000 for Baltimore City schools only to help with purchasing of art supplies and equipment. And she has resigned, so she's no longer going to be the chair or a legislator. And we're going to miss her because she's done a lot for Baltimore City and other districts in terms of education funding over the years. Another added addition to the budget, since there was a large this current fiscal year surplus in the budget, in the amount of billions, the legislature was able to secure $800 million dedicated to the Blueprint Fund. So I mentioned earlier that the Blueprint plan is going to cost nearly $4 billion and phased in over the next decade. And it was, the legislature has identified revenue to fund the plan for about half of those, half of the 10 years. With the addition of this $800 million to the Blueprint Fund, the plan is solvent through fiscal year 27. So that's good. That's a good thing. The money will be coming in over the next several years, and we won't have to worry about securing revenue until the out years. Okay. We don't know exactly what people will see in schools this year. There's a new state money. I mentioned 456 million additionally from the state this year. And there's still federal COVID relief money in play. It's complicated to understand, so it'll be important to watch what comes out of the Blueprint Accountability and Implementation Board. This is the entity that oversees all aspects of implementing the Blueprint plan. And they'll be issuing guidance to school districts in terms of how the new money is to be spent. And they will provide information and materials to the public in terms of what the public can expect to see in their schools as a result of the phase-in of this new money. And lastly, the last thing I want to say about the blueprint is that it's questionable as to whether or not the funding formula that's passed into this blueprint bill will actually fund the blueprint programs or actually lead to adequate funding levels for each school district. In my analysis, and we don't have all the information, it looks like the bill is going to fall short. So our mid to long-term goal is with the Bradford lawsuit and letting this play out in court. And we may be asking for a remedy in court to fill any shortfalls, anything left out in this bill. Okay.
Great. May I add something here about the blueprint?
Sure.
Sure. I just think it's important to state that the blueprint is a start. It is not, as many people say, it's the floor, not the ceiling. And so there's a lot of work still to be done. And what I would like for our constituents to know, or the public to know, is that this bill, this law is good, but it's like something that should have been done a long time ago. And the gap is huge, and we have work to do to make sure that the implementation of this blueprint is that we see racial equity in this, and that the monies and services get to our students. I've often said I don't want to see this money sitting in district offices or a bunch of consultants. And so I just think that this is really important for us to know that we still have lots of work to be done.
Right. One of the amendments that we worked to pass, proposed by leaders of the Beautiful Struggle, was to include culturally responsive pedagogy as a framework for teacher training to ensure that teachers are delivering education in a way that is culturally responsive. That amendment didn't pass back in 2020. But now with the implementation of the law, and there's a lot of language in the bill that requires teachers to be culturally competent, the public and advocates have an opportunity to define and to advocate what that should mean, right? And Shalimar testified recently before the Accountability and Implementation Board on teacher policy. So there's going to be definitely a lot more to do, a lot more opportunities for folks to get involved. Okay, let's move on to one slide up. Yes, ensuring safe, healthy, and modern school facilities. So this year, there's 1.2 billion for school construction for fiscal year 23, and this is 3 times more than the average. So we can expect to see somewhere around 350 to 400 million statewide for school construction. And while that sounds high, like a large amount of funding, school facilities are in such poor condition statewide, especially in places like Baltimore City and Prince George's County and some of the rural districts of low wealth. And the amount that's needed to bring all school buildings to adequacy to ensure that they're healthy and safe and modern is well over 20 billion. So 1.2 billion is definitely a record in terms of the amount of funding available for this fiscal year. But the state has to maintain this level for many years to put a dent in this problem. And the money's going to come through a variety of programs. One's called Aging Schools, that directs money to school buildings that are the oldest in the state. Baltimore City has the oldest schools in the state. overcrowding. So places like Montgomery County and Howard and some other counties are growing in enrollment, and they have a lot of relocatable or temporary classroom structures. So this is funding that comes through to help them add capacity to their existing schools. There's a healthy schools fund to address emergency health and safety needs, such as HVAC systems or leaking roofs, electrical problems. And there's a big pot of money for new construction and renovations. Also included in this 1.2 billion is a portion of this 2.2 billion dollars that comes from the Built to Learn Act that was passed in 2020, vetoed by the governor, and then overridden in 2021. So over the next few years, we're going to see the 2.2 billion come through, get distributed to districts, and most of it's going to be contributed to dedicated to new construction or full renovations. Another bill that passed is House Bill 1290, school construction funding. This is mostly about policies to ensure that there's more support for districts of low wealth. It includes something called the Revolving Loan Fund, which has $40 million in it this year. What wealthy counties do a lot of times is that they have a lot of projects that are ready to go. And they get a lot of local funding from their local governments because those governments have a lot more capacity to incur debt for school construction. So they fund a new school, and then it's a matter of submitting the receipts to the state for simple reimbursement when they get their money from the state. So it doesn't work that way for districts of low wealth. They don't have the money on hand to forward fund these projects. So it's much more complicated to get these projects in the pipeline and constructed. So the revolving loan fund will help districts forward fund projects so that they have similar advantages to wealthy districts. And then there's a statewide school facilities assessment. One thing that we don't have right now is all the data on school buildings statewide in a way that can be compared apples to apples. So, we can say that Baltimore City has a $3 or $4 billion need. Other districts have other levels of need, but they're not exactly comparing the same data. So this was an effort that we were able to secure funding for this statewide assessment a few years ago. The assessment was completed, but the data was not collected accurately, and the way it was presented was not done in a way that was comprehensive and accurate. So the Interagency Commission on School Construction at the state level is responsible for going back and ensuring that the data is collected and compiled in a way that is accurate and comprehensive, and hopefully soon available to the public so we can start to see the comparisons among districts. Okay, next slide. And just a few more things to mention. Ending the school to prison pipeline. So we and our coalition partners over the years have been working on fair discipline policy and practice in schools. And over the past decade, we've worked at the local and state levels to overhaul discipline policy with the goal of ending the school to prison pipeline, as Black and brown children are disproportionately suspended at higher rates than white students. More and more schools are suspending less and implementing programs to keep students in school and helping them with their social and emotional development through restorative approaches. We have made significant progress, but there's still a significant disparity and more work to do. House Bill 23, school discipline data collection, passed the House this year and stalled in the Senate. This is the second year in a row that this happened, and this bill would have provided or required MSDE to provide discipline data on suspensions and expulsions for every school in the state, disaggregated for race, gender, disability, ELL status, and age. ELL meaning immigration status. We've made a lot of progress over the past decade to ensure the approach to discipline is less punitive, but without having the data, school leaders, community partners, parents won't know what the trend is the trend happening in their school. So the idea is that this data would be available so that you can see the trends, right? Is my school trending in the right direction? Are the suspensions growing? Who's getting suspended? And this has implications for how you approach, climate issues at the school level. So we're going to be working on that next year. Counselors, not cops. The bill was withdrawn this year. So this was an effort to get the funding that's dedicated to school police and redirect that to counselors and mental health needs. The bill was withdrawn this year because an incident that happened in Montgomery County. But this doesn't deter us from our goal of getting cops out of the schools and investing more in mental health supports and other areas of need for students. Non-discrimination in publicly funded private schools. So we oppose public funding for private schools, and this is the Boost program, which provides some money for private schools. We worked with the coalition to pass House Bill 850, which prevents these public schools from discriminating, the private schools that receive public funding from discriminating against students and families based on race, gender, sexual orientation, family structure, things like that. So we call this a partial success because this is better than nothing, but our end goal is really to get public funding out of private schools. And that will sum it up for education. Thank you.
Thank you so much, Frank, for updating us, and also Shalimar for updating us about the really important work that has been done this last legislative session on education. Now we can take any questions that anyone might have. If you want to enter your questions into the Q&A, we have some time to answer any questions that you have. And just as a note, we are also streaming tonight's event on the ACLU of Maryland social channels. It's being streamed on Facebook, YouTube, and Twitter. So we also encourage you to share the recording that's going to be left on those channels after we close tonight with your networks, so that you can spread the word about the work that has taken place this past legislative session and start to engage more supporters in the future work that we'll be doing together. Are there any questions anyone would like to ask before we close tonight? We do have one question. Can you elaborate on public funding out of private schools?
There's a certain amount of money, and I'm sorry, I haven't looked at the amount. If anyone on the call knows, I think it's somewhere around 10 million. I don't want to misstate that though. But this program's been around for almost a decade. And this is state money that goes to private schools for families that apply to it, to the program. It's supposed to be prioritized for students from low-income families. But initially, when we first, and we opposed this the whole way through, but when the program did start, we were finding that it was students who were already going to private schools that was accessing this money. And we have received, in addition to that, we have received calls over the years on our legal hotline from families, mostly parents from same-sex couples, who have reported that either their child has been discriminated against, they have been discriminated against, they weren't accepted into a certain private school program, or their child is LGBTQ+, and was discriminated against. A student not being allowed to go to their prom because they have a date that is the same sex as them. So issues like that have come to our attention, but there has been no recourse, right? Private schools had the right to do that, basically. So what we've been trying to do is basically said this program exists, and those schools, private schools receiving public money, should be held to the same standards in terms of discrimination or non-discrimination as public schools. And that's what House Bill 850 does. It prevents them from discriminating, with some exemptions. So we call it a partial success, but again, we oppose the whole program overall.
Thank you so much, Frank. We have one more question here from Shalimar. I have a question about plainclothes police wearing cameras, whether that would blow their cover. Very good question. And I know that if Joanna is still on the line, hopefully she can address that question.
Sure.
Yeah, go for it.
Sure. So there is a difference between plainclothes officers and undercover officers. And one of the things I neglected to mention is that our bill actually did have an exemption for undercover officers. So they really are an officer who is literally in a covert operation where they are pretending to not be a police officer at the time. And different police departments have ways of categorizing them. Those operations have to be approved. There's a whole set of regulations that apply to that. Those are not covered by Quamina's law. And that is something that definitely created a tension, and is something we have to look at again to kind of figure out how we make sure that actual undercover officers don't have to wear cameras, while making sure that that exception does not allow individual kind of supervisors in police departments to override the requirement for plainclothes officers to use body-worn camera. So I hope that answers the question. I'm happy to try to answer it better if it doesn't.
Thank you so much, Joanna. Are there any other questions about either the body-worn cameras or any other of the piece of legislation that we talked about tonight? You can put it in the chat. You can put it in the Q&A. Oh, we've got one. Can you tell us more about the legislative calendar? When will you start to work on the next session?
It's a great question.
Yeah, go for it.
So this year we're in election year, so a lot of folks are kind of preoccupied until, as far as legislators go, are preoccupied until after the primary, which this year is in July 19th. So we'll start having conversations with legislators about kind of session. We're having informal conversations now, but formal meetings happening after the election happens, and meeting new folks who get into office. But as far as looking into the actual, what priorities we're going to prioritize next year, I think we have a pretty good idea of that, and that's going to continue the work that's left off from this session. And we'll also be having our Maryland Coalition for Justice and Police Accountability retreat again this summer, where we collectively decide and look at the police reform that we've worked on in the past couple of years, and kind of what's ahead. Quamina's law, as Joanna mentioned, is definitely going to be one of those bills. So we will be regrouping this summer and starting that work as soon as possible.
Great. Thank you so much, Yannette. Any other questions about our priorities or any of the piece of legislation that we worked on this session?
I'm seeing there's an additional question from Joanna. Joanna, I don't know if you want to just ask it directly to Frank.
Sure, Frank. I just wanted to know, I was trying to scan it, but if you could explain to us a little bit more of the religious school exemptions in the Inclusive Schools Act and kind of how you understand them to operate.
This was a secondary bill from we were involved with the coalition, but we weren't the leads on it. I'm not prepared to get into those details.
No problem. Thanks.
All right, any further questions that we can answer for you all this evening? Please do check out our legislative report that's been shared in the chat. And if you have any, please spread the word and help us to let people know, what victories we achieved this session and also what further work that we have to do together in the future. We have one more question. Did the medical parole not pass both chambers? I think that's for you, Yannette.
So it passed out of the House, it passed clean out of Judiciary, but then when it got to the floor, as I mentioned earlier, there was a harmful amendment that was adopted. So it did pass the House, but we were unable to get it amended and moved in the Senate, and the Senate cross-file version also wasn't brought up for a vote. So technically it passed out of the House, but it did not move at all in the Senate. And if I could just, before we close out, mention a couple of things. As I mentioned before, the Baltimore Civilian Review Board bill did not advance in the Senate this session, and there's a local bill being introduced. And it was just introduced this last Wednesday by Councilman Conway. And the second hearing is this Wednesday, May 25th at 1 p.m. In City Hall. So encourage folks who have been following this work to tune in locally. That hearing's happening this week. And then additionally, if folks have been following along in Prince George's County, we've been trying to get a public hearing scheduled so that we can inform the public about what's going on with the implementation of police accountability boards in Prince George's County, which is in a similar posture to Baltimore City having independent investigatory powers and civilian oversight. The civilian complaint panel that currently exists and has independent investigatory and subpoena powers, and they're trying to get rid of that and create another police accountability board without those powers. And so we're working to strengthen community oversight in Prince George's County and have successfully finally gotten a town hall scheduled, and that is going to be this Wednesday, May 25th at 6:30 p.m. And that will be at the Southern Regional Technology and Recreational Complex in Fort Washington. And you can find that information on our I'll drop the link in the chat, but also on our social media channels as well. And then also finally, the first official hearing for the Prince George's County Police Accountability Board hearing has been scheduled, and that will be May 31st at 11 a.m. and sign up is due the day before at 3 p.m.
We don't have any further questions. So Yannette, please close us out.
So I made my plugs in for upcoming events and such hearings. Please do support that work. And we look forward to continuing to work with you all. And please reach out if you have any questions that we didn't get to tonight. And thank you again for joining us tonight.